Hi, Doc. Hello, can you hear me? Hi, Doc. Are you able to unmute your mic? Okay.
So can you hear me now?
Yes, I can hear you perfectly.
Okay.
So do you have your presentation open on your computer?
Yes, on my desktop.
On the desktop? No, perfect. It's open on the desktop. When you
Okay.
when you take your cursor, let's say you've opened the Zoom application. If you take your cursor down,
Okay.
sir, when you take your
I
cursor
opened
down,
already. I opened already. I am in the our site, and it
okay,
shows
no,
here down mute start video. Botswana
yes.
doctor. Can I click on start video?
So it's actually no, it's supposed to say share. No, not start
Not
video.
now.
Yeah, no, start video is to show yourself.
Yeah.
Start.
So that is myself.
Yes,
And
and then
share screen. I have to click on the
yes,
share screen.
yes, you click on the share screen.
Okay, I'm clicking the share screen.
Yes.
And here share.
Yes, and then do you see
Right.
your?
I'm sharing, and here
Yes. Oh, perfect. Yeah.
PowerPoint.
Yes. Great.
Okay.
Great.
So are you able to see?
Yes. No, I'm able to see. I'm able to see.
Okay.
Now it's there. Now it's there.
Okay. Slideshow
Then
from beginning.
slideshow from the beginning. No, then it's perfect now.
Is perfect.
It's perfect. Yes, sir.
Okay. Your screen sharing. Yeah.
Yes.
All
Yes.
right.
No,
So you could see my face also.
I can see your face also, sir.
Okay. Thank you very much.
And this is my face.
Okay.
Yeah. So that's
But your face was cut. You have to lower
oh,
a little. All right.
oh,
Now I
can you
can
see?
see you. Now
Okay,
I can
great.
see
Thank
you.
you so much,
Thank you.
sir. Thank you.
All right,
So,
Dr. Moyela.
yes, sir. So
So shall I
we'll
keep
just
like this?
you can choose whether to have your video on. The only
Okay.
issue with keeping your video on is internet. If your internet is not so good, the video is going to eat from the internet. And then if
Okay.
people have bad internet, they may struggle. But if you prefer presenting with your video on, then perfect. So for
Yeah, no
now,
problem. Because
okay.
mine is 10 MBBS speed.
Wow. No,
Yeah,
then great. No, then
that's great.
great.
No
Okay,
problem.
no, then we'll just give we said 6, so we'll give them 5 minutes to join in, and then
Okay.
we'll start.
Okay.
Thank you so
Shall I
much.
click on the stop share?
No, you can leave it. You can leave it.
You can leave. I can leave like that.
You can leave
Okay.
it.
Okay. No
And then,
problem.
and then if you want, you can mute for now. You can mute their
Okay.
mic for now, and then when they come in, then we can unmute.
No problem. Okay.
Thank you
Okay.
so much.
Thank you.
All
Thank
right.
you.
Thank you so much, sir. Hi, Doc. Don't worry, they're still joining in. I expect maybe we can give them 2 more minutes and then we start. Apologies for that.
So no problem, I will wait. Thank you, Doc.
Thank you. Hi, Doc. I think we can start now. So I'll just hand over the podium to you for you to just begin. I think I was going to introduce you, but I felt like I won't do you justice. I saw your resume. It's a very heavy and very powerful resume. You are a man with very rich medical background. So I just wanted maybe you to do the honors of just introducing yourself to the audience. But otherwise, I welcome everyone who's part of this presentation today. Thank you.
Good evening, Dr. Muyela. And good evening, comrades. Thank you very much. And I thank you for giving me this opportunity to present this presentation. Hope I am hearing you. Hope you're hearing me, because it is one way I am not able to see my audience. So it shows, so it is first time I'm presenting on the Zoom. So you can hear me, isn't it?
You're very clear, sir. We can hear you.
Very clear. Okay, okay. Okay, thank you. So thank you, Dr. Muyela, and comrade, thank you very much, and good evening. So today I want to present Botswana Mental Disorders Act and modes of admission into a mental hospital. Srikant Davu, Dr. Srikant Davu, and my qualifications are MBBS and MD. MD is the post-graduation. Here we call Masters of Medicine. So I did my post-graduation in psychiatry. I'm a consultant psychiatrist working at Sbrana Psychiatric Hospital for the last 12 years. So now I'm going into the presentation proper. Sorry, some technical. Dr. Muyela, why it is not moving?
I'm not sure. Maybe just click again on the screen. Is it moving?
On the screen.
Yeah, on
yeah.
Just double click
like that on the screen, yeah.
Yes.
So now, yeah. So Botswana Mental Disorders Act. Actually, this act was drafted in 1969 in Botswana, and it came into force on 23rd April 1971. So it makes the provisions to receive, to detain, and to treat and protect the mentally disordered persons. So there are 4 components in the Act, mainly to receive, to detain, to treat, and protect the protection of the mentally disordered person. And you see, there is a very important provision in the next paragraph. The Act proclaims that merely a person is having mentally disordered, we have no right to detain in the hospital except by virtue of the provisions of this Act, and also in accordance with the provisions of the Part 12 of the Criminal Procedure and Evidence Act, we call CPE. So the sections 157 to 175. And my friends, this is called forensic psychiatry subject. Like in medicine, you have subspecialties in medicine, like cardiology. After general medicine, we have to do cardiology or gastroenterology, neurology, like that. In psychiatry also, we have subspecialties. First, we do the general psychiatry, then forensic psychiatry if you want, which is dealing with the law, or adult psychiatry, pediatric psychiatry, geriatric psychiatry, licensed psychiatry, and addiction psychiatry, a lot. So unfortunately, all these subspecialties are not available in many developing countries. Only a few developed countries, so including South Africa, they are having the subspecialties. But other countries, so general psychiatrist will take care of all the subspecialties usually. So in our hospital, we have adult psychiatry, pediatric psychiatry, geriatric psychiatry, forensic psychiatry, addiction psychiatry. But only we general psychiatrists will take care of them. So this is forensic psychiatry subject. So the Act proclaims, no person shall be detained in an institution or elsewhere on the grounds of being mentally disordered. That means, so simply a person is mentally disordered, we cannot detain him, except by virtue of this Act and also CPA, which I will explain you later. Sorry. So there are 12 parts in this Act and 53 sections. So I will briefly detail what are these parts. Part 1 deals with the preliminary, like definitions, etc. Part 2, so reception orders. Part 3, the effect of a reception order. Part 4, urgent cases. Part 5, provisions as to the medical certificates. Because whatever the medical certificates and applications, there are prescribed forms are there. So in those prescribed forms only one should apply. Next, part 6, procedure after issuing of reception order. Part 7, patients residing in private dwelling houses. That I will also explain, but nowadays we are not using these private dwelling houses, the issue. Part 8, review and termination of detention. Part 9, temporary treatment of voluntary patients. Part 10, mental health board. Part 11, offenses and penalties, and part 12, general and supplementary. These are, in brief, how many parts are there in the Mental Disorders Act. And I will go one by one, which are only relevant to us. And the classification of mental disorders by the Act. I think doctors, we are all aware that in psychiatry, we use the word mental disorder. We don't use mental disease. I think you know the difference between a disease and disorder. So WHO explains in ICD-10, International Classification of Disease, clearly, disease is the one in where there is an identifiable lesion which can be diagnosed by known laboratory or imaging services. See, for example, TB is a disease. So we can identify the lesion, and also by laboratory test, we can diagnose it. Whereas in mental disorders, so disorder is, so there is no identifiable lesion and there is no lab tests, either lab tests or so image services. For example, depression, we cannot identify by any X-ray or by any scanning or any blood test. That is why, so that we call it a disorder. they are syndromal basis, a group of symptoms and signs. But we cannot identify them by any lesion, or we cannot diagnose them by any no laboratory tests so far. So that is why we use the word disorders. So the Act classifies mental disorders into 3 classes. Of course, in the psychiatric book, there are so many disorders are there. So it is not the psychiatric classification, it is the legal classification in Botswana. So there are 3 classes: class 1, class 2, class 3. Class 1 are the persons who are danger to themselves or to the others. So they are class 1. Class 2 are, they are neither danger to self or to others, but they have, so they are suffering from mental illness, but they cannot take care of themselves. And they are vulnerable to be abused. That is class 2. Class 3 are similar to class 2, but they differ that they don't need required skill attention. So class 1 and class 2 only will be admitted in mental hospitals, and class 3 not, by reception orders. I will go through it clearly. Admission into a psychiatric hospital are through 2 modes. So we admit the patients in 2 modes. One is voluntary mode and another is involuntary mode. Involuntary means against their will. So involuntary admissions may occur through 2 processes, either by virtue of this Act, Mental Disorders Act 1972, or through the CP Act, Criminal Procedure and Evidence Act, which I'm going to explain you later. And involuntary admissions are done again in 2 processes again. One is by reception orders and by urgent applications. So reception orders and by urgent applications. I will explain one by one. So first I will explain the reception order. A family member or any other person who has attained age of 21 years, who has seen the client at least 2 weeks before, can give an application to the district commissioner for reception order. So any family member or any person who has seen the client 2 weeks before can apply and sign an application. So there is a prescribed form for that. You have to go to the district commissioner's office and give the application. Upon receipt of the application, the DC must inquire on the matter publicly or privately. And sometimes the DC can visit the abode of the patient or order the patient to be brought to his office and be brought before a medical practitioner also, or himself, if the patient will not voluntarily appear. So the DC has the right, the patient can order the patient to bring him to his office or to the office of the medical practitioner. The DC has discretion in accepting or denying the reception order application, but is bound by the opinion of the medical practitioner. See here, the DC can deny the application at his discretion. But once he accepts it, he has to follow the medical certificate, so medical practitioner's opinion. Yeah, so it is a must, because he is not a medical doctor to know whether under which classification these mental disorders are coming in. There is class 1, class 2, class 3. So it is only the doctor who should know which class the patient belongs to. So a medical certificate is a must. So if satisfied, the DC issues a reception order prescribing the duration and institution for detention or temporary treatment. So usually, district commissioners will issue the orders wherever there is inpatient facility in the country. In Sbrana, in Lobatse, and in Jubilee Psych unit there in Francistown, and Mahalape there is a unit, and we have units all over the country. So the DC can issue a name on the institution. And this order is valid only for 30 days. And after expiry of the 30 days, then the medical officer who is treating the client or in that institution, so not the medical officer who is treating, the other medical officer will issue so another certificate for the extension of some more days, another 30 days. Like that, we can have a cumulative 90 days only. After that, Either we have to discharge the client or make the client as a voluntary patient. So once because after 90 days, definitely the patient will become stable. Most of the patients will become stable within few weeks actually. So it is rare that the patients may not become stable after 90 days. And there are patients who cannot become after 90 days. Then they may know what they are suffering from by that period, and we'll make them as voluntary patients. And if it's more than 90 days, also there is a provision. In issuing the reception order, the DC sends a copy to the Master of the High Court and provides an inventory of the patient's assets. So when the DC is sending to the patient to the hospital, then he has properties and all, and the inventory will be sent to the Master of the High Court. From here on, we'll explain as Master, not the Master of the High Court fully, and I will call as Master. Upon admission to the health establishment, the superintendent of the hospital within 10 days remits a report of the patient's mental state to the master, who may order further detention, appoint a curator bonis, or discharge the patient if requested by the superintendent. So within 10 days, the superintendent will give a report to the Master of the High Court, and who may further detain or appoint a curator bonis. Curator bonis is nothing but appointing a person who will take care of patient's properties. It's called curator bonis. It's a Latin term. So there are two types, curator bonis and curator ad litem. So curator ad litem is the one, to appoint a legal practitioner on behalf of the client. But here it is curator bonis. So it is usually the High Court, the Master of the High Court, who will appoint a curator bonis to take care of the patient's properties. So after 90 days, sometimes if you need more time to detain the client under involuntary, then we have to go to the Master of the High Court, but that rarely happens. And next, so that is one, also reception orders. And now we come to the urgent applications. Sorry, the urgent applications. In the urgent cases, a family member or any other person who has attained the age of 21 years and who has seen the client in the preceding 48 hours makes an application to health establishment. That means, so there's an application, a prescribed form is there. Any family member or any other person, and also I will give the list of the people who can apply for urgent cases. Suppose the patient is very violent and he's obstructing on the road and all. So who can bring such clients to the hospital? So any family member or any member who attained to an age of 21 years make this application to the health establishment. The applicant needs to state why the patient is mentally disordered or defective and must produce a medical certificate based on examination carried out by a medical practitioner within preceding 48 hours. So when he's when the client is being brought by the relative or somebody, and we need a medical certificate also, so which was done 48 hours before. That means the patient can be taken to a nearby hospital. And since the patient is very violent, sometimes the ordinary persons or family members may not take him, and they have to go to the police station. So with the help of the police, so they can take the client to a nearby medical establishment, and a medical practitioner should have seen the client. And then he has to be brought to our Sbrana hospital or any other mental health unit. Upon admission of the patient to the health facility, the applicant of the urgent application must immediately report to the matter to the district commissioner for an application of reception order. So this urgent application should be turned into reception order. So how much time they gave? The Act gave 14 days. 2 weeks time is there. This reception order should be granted within 2 weeks. If there is no reception order granted, then the patient should be released. So if the reception order is granted, so we follow the process as explained and above. That means, so first 30 days, next 30 days, next 30 days. Until 90 days we can follow. That means this urgent application will be turned into reception order. Suppose the DC has not granted reception order it would be unlawful to detain the patient further. We cannot detain him more than 2 weeks if the DC has not issued the reception order. And who can apply for the urgent application? These are the list. Husband or wife or any near relative or any person above the age of 21, any administrative officer. Here, the Act doesn't say whether it is public administrative officer or in a private setup. Any police officer of above the rank of sergeant, any headman or any member of a city, town or district council or of any township authority who has reason to believe that a person apparently mentally disordered or defective is dangerous to himself or to others. So these are the people who can go for an urgent application. So this is a temporary provision. Now, so voluntary admissions. Now we have seen how the involuntary admissions patients are admitted in the hospital. Now we go for the voluntary admission. So Part 9 of the Act describes procedures for voluntary admission. And in voluntary admissions, the Act doesn't prescribe any classes of the mental disorders. So there are no classification of mental disorders. So persons of 16 years and above may make an application to be received and detained as voluntary patient in a health establishment. That means any person above the age of 16 can come to our hospital and so he can fill up the form. There is voluntary admission form. And then we can detain him and we can receive him, we can detain him and we can give the treatment and protect him. Those younger than 16 years of age, the children, so usually the parents are required to give the application on behalf of the children. Of course, the decision to receive and detain them is at the superintendent's discretion. Then how they can be discharged? They can be discharged. Patients are required to give 1 week's written notice if they want to be discharged prior to become stable. So before that, also superintendent can take a decision, because on behalf of the superintendent, we the treating doctors or the ward medical officers or ward psychiatrists will take a decision on behalf of the superintendent. So superintendent may allow discharge before the expiration of the notice also. Okay, this is how we admit the voluntary patients and we discharge them. So private dwelling. And so usually nowadays we are not following, maybe in 1960s when there are no psychiatric hospitals or no hospitals, probably these so these provisions were made in the Act, but nowadays we are not using. So the patients who are class 3, it's mostly class 3, those who are neither danger to self or to others, but they need some sort of help and they may not take care of themselves. So they can be taken care in private houses. So section 13 and section 29, so still provide those things. This allowance may be granted in terms of section 13 by an order in lieu of reception order or in terms of an application by caregiver as described in section 29. So it is in place of reception order. So section 29 relates to individuals whose mental illness have continued for 6 months and who require compulsory confinement or restraint to receive care in a private dwelling. So private dwelling. So persons with charge of such patients must furnish the DC with a medical practitioner report. So here again the procedure, how we can put a patient in a private dwelling house. So they have to give an application again to the district commissioner. Then, so by backing a medical practitioner certificate that he is suffering from mental disorder and what class also. Then the DC will inform the Master of the High Court. Master of the High Court is the one who will so give this order. The master may grant the request for private care or recommend an application for reception order and appoint a curator bonis. So Master of the High Court is the one who will grant for the request to be treated in a private care. Of course, but the DC is the responsible for monitoring such patients' care. The care offered in terms of Section 29 is provided by non-remunerated individuals and is provided in a private dwelling. Please note down here, the private dwellers are not supposed to take any charges from the client. Of course, the system is not there and we have not seen any patients treated in a private dwelling houses nowadays. Protection of the patients, their rights. The Act provides a protection for detained persons with mental illness. Orders made regarding them may be appealed and reviewed. Yes, they have a right, so they can go to the High Court. And of course, many of our clients also going to the High Court, and we have regular cases. They filed a case against the hospital, case against the psychiatrist, the case against the district commissioners, and many such cases are pending that they accuse us that they were detained illegally, not following the Act, and they were detained, they were not mentally sick, etc., etc. So they have a right to go to the court. Their properties are protected via a master's appointed curator bonis. Yeah, it is usually be done. Patients are protected from ill treatment by practitioners employed in their place of detention. Yes. And we are not supposed to ill-treat the client. Even if the client is hitting us, we are not supposed to hit back. So we have to go by defensive, not offensive way. And so usually, so these things will happen. When we restrain the client, they may think that we are attacking them, and we give them psychoeducation, and we give psychoeducation to the parent and to the caregivers also. And sometimes the patients will misunderstand that thing, and they will file a case against us, and we go to the courts and explain our stand. This later protection includes the limiting of mechanical means of bodily restraint. So here we restrain sometimes when a violent patient is coming and he is not following our, and he is not willing to take injections or any medications, then we have to restrain physically. But of course, only a few seconds only. Nowadays, we are not restraining by chains or anything, which so usually done in early 20th century or in 19th century. They are called mental asylums. Actually, why these acts came into being? To tell you that one, almost all countries, so UN member countries, have these type of acts to protect the rights of the mentally sick patients. In World War II, particularly, psychiatry was highly abused medical specialty. And in some countries, if they don't, some intellectuals, if they don't follow their ideology of some political ideology, they were labeled as schizophrenics, and they were given electric shocks, and they were admitted in psychiatric hospital asylums, and they were cruelly treated. And so after Second World War, so UN was formed, and so UN chats of so human rights has happened, and under the UN leader, this thing, many countries drafted the Mental Disorders Act. In some countries called Mental Health Act, and in some countries called Mental Disorders Act. So since Botswana is part of UN, and so we have this Mental Disorders Act, not to abuse the rights of the mentally disordered patient. It is mainly to protect them. The acts are to protect them. So that is why we have this act. And psychiatry is only subject in medicine where we act, where we practice by following the act. Unlike medicine, unlike surgery and all. So we follow and we admit the clients by the way of this act only. And we treat by the way of this act. Next. So we have another board called Mental Health Board under Part 10 under sections 38 to 40. The Mental Health Board will be appointed by the minister and as prescribed in this act. will ensure that well-being of the persons detained under this act is upheld, that place of detention and conducive, and the patient's complaints and wishes. So the mental health board usually minimum 3 members, and one of the members will be a medical practitioner. But now we have nearly 9 members. But in the act, when it is envisaged long back, it was only 3 members. And 3 members, one of the members will be chairperson. Usually he or she will be a medical practitioner. So they have to go to the mental, wherever the psychiatric patients are admitted or treated, and they have to see that whether they are taking care, whether the staff and the doctors taking care well of them, and so how the place is, whether it is hygienic or not, all these things. And they go to the patients and they inquire the complaints, and whether the complaints were taken care of. And so they come every 6 months to our institution. The board of no less than 3 members, one of them, as I explained to you, as a medical practitioner, is required to visit health facilities detaining person with mental illness at least once in 6 months. So the mental health board will come to our hospital and do the inspection. And if any complaints are there given by the patients, and we look into it, and so we rectify it. So we have restraining units, restraining what you call rooms, so restraining room. Because when the patients are very violent, and for a few days, we put them in the restraining room, and that room is specially constructed, and the wall will be foamed. There is a foam, and even if the patient is hit to the wall, he won't get injuries, and the floor also will be foam, and there will be so air conditioned, and the roof will be very high, and no rods will be seen, so that he won't injure himself, or he may not commit any suicide or anything. They are called restraining rooms. It is it we call environmental restraint. There are three types of restraints. One is chemical restraint. That means we give the medicines, we give the injections so that they will become calm. It is called chemical restraint. Then physical restraint. Sometimes we will hold the client for a few seconds to give the injection. It is called physical restraint, only for a few seconds only. And then environmental restraint. We keep the person in that restraining room, and for a few days we have to, because until he becomes stable, the psychosis is reduced. We keep them in the restraining room. And restraining room, we should not keep more than 2 hours as per the act. So we have to open the door, but of course, every 1 hour, our staff will see the client's the vital signs, and also they will inquire and see about how he is doing. Every 1 hour, we open the door. Once you open the door, so restraining is so restraining process is ended. And once we close the door after inspection, so after taking the vital signs and etc., then once we close the door, then so restraining process is restored, and there is a register for that. And this one we have to, the superintendent is bound to send to the master of the High Court, and we have to provide the register to the mental health board whenever the mental health board is visiting us. So these are the board is required to observe, give audience to every patient, and report to the director the results of any visit and inspection, as I told you already. So they report to the director of health services, whatever they inspected and all. And another important function of the board is some patients here under the CP, Criminal Procedure and Evidence Act, under Part 12 of CPE, they are committed by His Excellency the President, and they are called Special Presidential Detainees. SPD, we call them in short form. So the board also will inspect such patients admitted by His Excellency the President. Now, this is about our Mental Disorders Act in brief. And before I am going to the Criminal Procedure Code and Act, may I ask Any doubts on that Mental Disorders Act, or so shall I complete, Dr. Muyela, the whole, and then we come to the questions? Hello, Dr. Muyela. Sorry, and so I will continue, and after that we'll come to the comments and question at the last. But I don't have any problem to answer your questions in the middle also. So now, Botswana Criminal Procedure and Evidence Act, Part 12, sections dealing with the mental disorders is 157 to 175 under Chapter 8, 02. So it has 157, and I need not to tell all the sections, and I will describe here only they which are required. So 157 is the interpretation of this part. 158, inquiry by a court as to lunacy of accused. There are 6 subsections in this. So what is this? Actually, some of our clients, mentally disturbed clients, may do some unlawful activities like rape, murder, under psychosis. Lunacy, you have seen the word lunacy. It is an old terminology in 19th century terminology. Lunacy means madness. Lunacy is the Latin word. So general English name is madness. Why lunacy? Because in those days, they thought that the movements of the moon will be affecting the patient suffering from mental disorder, and they will become mad due to the movements of the moon. Moon is called lunar. That is why the madness was in Latin term, it is called lunacy. So when the patients are under psychosis, nowadays we are not using such abusive words, we are using psychosis. When patients under psychosis, they don't know what they are doing, and sometimes they may commit some murder or major crime, criminal activities like rape, grievous injuries, etc., etc. Then the courts will do the trial. The trial will be done first by the magistrate court, and then the magistrate courts will refer the case to the High Court. Then in that case, if the High Court found any evidence and proof, then the High Court will refer the case to the President. So this is the basic thing. Now I will explain one section by section. So under 158 subsection 5, in either case of the mentioned subsection 3 and 43, the judicial officer shall report in case of a magistrate court to the High Court. Suppose a client committed some murder, for example, and the judicial officer during the trial, judicial officer means in the magistrate court they are called magistrates, and in the High Court they are called judges. So they may find that the patient is mentally disordered. Then he will order for a psychiatric report, and he will refer the client to our hospital, and what we do the sanity assessment, the assessment of the client, whether at the time of the incident, whether he was suffering from mental disorder, whether he was psychotic or not. Because it is like we do psychological postmortem. We have to tell the court at the time of the incident whether the client was suffering from psychosis or not. Plea of lunacy, plea of insane. We call insanity plea. The client will go for insanity. I was insane at the time. On his behalf, so his defense lawyer will argue that my client was insane at that time. Then the judicial officer will send the client for assessment by us to the psychiatrist. So we do the assessment. It takes nearly 4 to 5 hours, or sometimes months together. We have to observe the client for a few months or a few weeks. So after the assessment, we'll come to a conclusion that at the time of the incident, whether the client was suffering from insanity or not. So what we do basically is the psychological postmortem. We rely on the patient's condition and assessment, and also other medical reports at the time of the incident. So we are trained in that. Actually, psychiatrists are trained in that to give to the judicial officer. My work in Sbrana hospital is, in addition to my routine clinical work to treat the patients, I assist the various courts in the country by providing the psychiatric assessment reports. And so far I have submitted more than 1,500 reports. And I have attended almost all courts in Botswana, including the Court of Appeal. And almost all high courts and also many magistrate courts I have attended and gave a witness on behalf of our clients. So in section 158, when the client, when the judicial officer in doubt that if the patient is having any abnormal behavior, then he will go for then he will send the patient to Sbrana hospital or in North. So we are now only three psychiatrists, but of course, 2 months before I am only the one, and then now two months before another psychiatrist came, and so we give the sanitary reports to the court in the South. Whereas in the North, there is one psychiatrist who is giving reports to the courts. Now, under 158(6), section 158 and subsection 6, on consideration of report made to him in terms of subsection 5, the president may order the accused to be confined during his pleasure. So what happens? Suppose the client was referred to me, then after examining him, I will give a report that so he was suffering from insanity, but he is still suffering from psychosis and he is not fit for trial. But he is not fit for trial. Then the magistrate will refer the case to the High Court. Then High Court will refer the case to the President. So His Excellency. The President then, under 158 subsection 6, the patient will be detained in our hospital under the pleasure of the President. The trial was not done. You see here, the trial was not done in this section because the client was not fit for trial. But sometimes the client may become fit after some weeks or months. Then again, the trial will proceed. Then when the trial has proceeded and when the judicial officer coming to a conclusion as what happens, it is explained in further sections. So in section 160, where an act or omission is charged against any person as an offense and is given in evidence on the trial of such person for that offense, that he was insane, so as to be responsible. So what this section says in brief is that section 161, after the trial, so we give a report that the client was suffering from insanity or psychosis at the time of the incident, but now he is stable and he is fit for trial. Then the trial will go on. So usually the trial will go on in the magistrate courts first. Then the magistrate, after some brief trial and all, the magistrates will refer the case to the High Court. Then the High Court will do the further trial, and sometimes they may call us and we go there and give the evidence. And after that, so the High Court will find a special finding. What is that special finding? The client is guilty because there is evidence that he killed somebody. He is guilty of the act, but was insane. Guilty, but insane. So this is the ultimate finding by the courts. Then the High Court will inform to the President's office. Then the President will detain such client in the hospital under the pleasure of the President. Pleasure of the President. So this is a very important under 160 section, guilty but insane. I think how this has happened. Psychiatric patients, when they commit any major crimes, they are not they are guilty but insane, but they are not convicted. They are not convicted. Though they are guilty, but because of the insanity, they are guilty but insane, but they are not convicted because they were not given a fixed term of prison imprisonment, but they were put for safe custody either in the prison or in mental or psychiatric hospitals. This provision actually came in 18th century, a case called McNaughton case or McNaughton law in 1808. In England, a patient by name McNaughton killed, he wanted to kill actually the Prime Minister, because he thought in our nowadays diagnosis, he was suffering from delusional disorder or schizophrenia. So he was thinking that all his problems are due to the Prime Minister of the country. So he wanted to kill the Prime Minister. So he thought, he killed his secretary thinking that he was Prime Minister. So he killed. And then a jury was formed whether he can be convicted or not. So 12 judges are appointed by the Queen, and they came into, then after a lot of deliberations, they formulated the law known as McNaughton law. McNaughton law says such clients, those who were insane at the time of the incident, were guilty. Were not guilty because of insanity. In some countries, they are not guilty because of insanity, but in other countries, like in Botswana, they are guilty but insane. But they will not be convicted to the prison, or they cannot be hanged. They cannot be given death punishment, and they will be put for safe custody or treatment in mental hospitals. After treatment for some time, they will be released under this act. In Botswana, they will be released by this act. I am going further on this. So under section 160, where a special finding is written in a magistrate court, such court shall report to the High Court, and then the High Court will inform the President, as I explained you earlier. And under section 160, subsection 3, the President may order such persons to be confined during his pleasure in a place of safe custody. Place of safe custody are two, the prison or psychiatric hospital, particularly Sbrana only, where we are keeping such clients. So they are admitted under section 160, subsection 3. And 161 says, so resumption of a trial again when they become stable. They committed a crime, but at that time they were not fit for trial. And after treatment, they will become stable. Then we give another report to the courts that now the client is fit for trial. Then the trial will go on. So under section 163 is a very special section. And if you read, this applies to the mentally retarded people and also suffering from schizophrenia or any other mental disorder. Such people might have killed somebody or raped somebody or might have done some grievous injury. They were insane at that time, for example, insane, but they cannot become fit for trial in their lifetime because their intellectual development was not didn't happen proper, and they are suffering from intellectual deficiency disorder, or we call mental retardation. So High Court shall make thereon such order as it thinks fit. So such patients, so High Court should take a decision and where they should be kept, either in the prison or in a special house, special home, or in Sbrana. So the High Court will take a decision about such patients under 163. So there are two safe places. One is prison and in Sbrana hospital for such clients. And they can be transferred also from prison to Sbrana hospital or from Sbrana to prison. When such patients are very violent and we cannot manage them in the hospital and they pose very high risk to themselves or to the staff members, then we request the Director of Health Services to transfer them to the prison. And from the prison also, they may be brought to our hospital. We temporarily appoint them, and also we can treat them, and then we can discharge them. So the transfer of such clients will be done under this section, section 165. And this one, and from 165 to 169, So these are 166 says notification of confinement, 167 inquiry into continued confinement, 168 appointment of curator bonus of person's confinement, 169 reports, etc. So under 170 section, when the patients are becoming stable, but here the section state cessation of mental disorder. Unfortunately, many of the mental disorders cannot be cured. Only they can be treated only. They may become stable. They cannot be treated, they cannot be cured completely. But anyway, when they become stable, then we present that case to the mental health board. As I explained earlier, the mental health board will come every 6 months. Those who are stable enough for some years, then we present to the mental health board. Mental health board, then the report will be forwarded to the Director of Health Services. Director of Health Services will forward the report to the Office of the President. Then Office of the President may take a decision, either continued confinement or release of the client. Or if not, cannot be released, and Office of the President will ask us what to be done next. All these things under section 170. Under 170, it will be done. So every 6 months, the mental health board will come to our hospital and we present such clients, and they are being treated by multidisciplinary clinicians, by psychiatrists, by general practitioners, by psych nurses, psychologists, social workers, and occupational therapists. So all these clinicians will give their independent reports to the psychiatrist, the treating psychiatrist. Then the treating psychiatrist will write a comprehensive report, and the comprehensive report will be presented to the mental health board. So mental health board will have many questions to the psychiatrist and my team. Then if they are satisfied with the report and the condition of the client, mental health board will also examine the, will also do the interview to the client as well as his caretakers. Once the mental health board is satisfied, then only, and the board will give its report to the Director of Health Services. And such patients, they are long-standing patients. But our minimum length of stay for such patient SPDs or in our hospital is 14.7 years now currently, 14.7 years. So what we do, and so we give psychotherapy to them, and we teach them various skills by the occupation therapy unit and all this. And also we give them, those who are stable patients, every 3 months, 15 days leave to observe in the community how they behave. Because in the hospital, after some years, maybe after 5 years, 6 years, they may behave very nicely, but it is under protection, in a protected environment. But we want to see how they behave in the community. So every 3 months, we give them what we call therapeutic leave for 2 weeks. And if they, under the observation of the local social worker, and so our social worker also will monitor. Then if they are behaving well, they will get another 15 days every quarter, like that. And also some patients, those who developed some skills, those are employable, we find employment for them so near to Lobatse, and our social workers and occupational therapists will transport them to that workplace. And from the workplace, they will be brought back again. And sometimes the employer will provide the lunch, and they may give some salaries also to our patients. And those amounts will be deposited in their own accounts. This is called Sheltered Employment Program, which you are following, which is there in the UK. We are following the same process, the same thing here in Botswana. It's called Sheltered Employment Program. So, so these are some of the things. And when the client is stable and we are satisfied, our all specialists are satisfied, we present this to the mental health board. Then mental health board will take a decision. And so other sections, 171 false statements, 172 ill treatment of persons, 173 conniving at escape of person. We are not supposed to connive with any clients to escape. and employment of male person in custody of females in female ward. So we don't employ any male persons because it is prohibited by law. And except doctors, and nurses. Usually we don't appoint male nurses in female wards. So except in emergencies, where the superintendent can give permission to go and restrain for restraining purpose in the emergencies only. After that, they have to leave the ward. So 175 shows the penalties. Any person convicted of any offense under section 170, 172, 173, they have to pay fine 500 pula or 12 months imprisonment or both if you violate any these things. So these are my references I used for this presentation. Thank you. Questions and comments. Yes, Doc.
Thank you so much, Doc, for your very beautiful and enlightening lecture. It was very, I learned quite a lot, to be really honest. I think there's a lot of comments. I'm actually surprised that we didn't have a lot of more doctors part of this today's presentation. More so that there's been a lot of questions surrounding mental health disorders as well as what to do. And you've really detailed the different processes on how to, approach a patient with a mental health disorder. So I see comments in the chat box. So maybe I'll start with the comments. I can read them for you, or you can read them. You can tell me which one you prefer, and then from there we will go to any questions from the virtual audience. So should I read for you the questions, or do you prefer to read them yourself?
I am not able to. Shall I click on the chats, probably, Doc?
Yes.
Yes.
Okay, right. On the chat. Yeah. So then, so you have about 3 questions,
Okay.
and then 1 comment.
What is the meaning of private dwelling? Some more clarification on that. Thank you, Doc, for asking these questions. Private dwelling is actually the concept maybe in 1960s when there are no hospitals. Private people on humanitarian grounds, they should not charge anything from the clients. And in the house, they have to take care of those mentally sick, those who don't have any relatives, those who don't have any parents and or take carers. So the act envisaged such a class, but we are not using, but we have no knowledge about any one patient nowadays being treated in a private dwelling house. That is only class 3 patient. Class 3 patient means they are relatively stable. They don't need specialized care. They need maybe food and shelter, and they need somebody to give them some hygienic bathing and all, and also some the pills or injections regularly. So such thing is not there, but though it is there in the act. But so far, we don't have any private dwelling patients so far. I think I have answered. Next one, can you clarify more on presidential CP? Yeah, so presidential detention. So when our clients, I think I explained, but it is a big topic. When the psychiatric patients, they may commit some crimes, stealing or common nuisance, but there are small things, but major crimes like murder. And when they commit such murders, when the judicial officer thinks he is mentally sick, then the trial will be postponed. Then the judicial officer will give a court order to us to assess the client. We first admit the client. Sometimes we will admit, and when the patient becomes stable, and then we will we do psychiatric assessment, and then we give the report. For example, a patient also recently, he killed his mother. I need not to, I don't want to violate the confidentiality. He killed his mother. Why he killed his mother? he was suffering from psychotic disorder. The God is telling him, he was hearing the voice of the God telling him, demon entered his mother's body. So kill the demon. So he took something in the house and hard objects, and he hit his mother, so who was a teacher, on her head several times and the body several times until she died. And the God told him to take rest. And he was taking bath in the bathtub. In the morning, people came and saw this gruesome scene, and they informed the police. When police came, God again told him, I gave you the power to raise your mother. So he was praying. The mother didn't. So the police arrested him, and they took him to the magistrate court, who remanded him to the hospital. And he was admitted here, and he gave the version that he was hitting the demon. He was killing the demon, not his mother. So he was insane at the time of the incident. After 3 months of treatment, he regained his consciousness. All his psychotic symptoms were reduced. Then even then he remembered everything, and then but he was fit for trial. So we gave another report to the court. He is fit for trial. The trial continues. And so such patients, the magistrate will refer to the High Court. The High Court will refer to the president. He was guilty but insane. Then he will not be convicted because he was insane. So what the courts will do, what the president will do for the safety of the community, they will be kept in either in Sbrana hospital or in prison for safe custody. They are not prisoners, but they are patients. They can be only released through mental health board, as I explained earlier. I think I answered that question. Next question. In case of a patient brought with a history of abnormal behavior, both physical and verbal aggression after substance abuse, without any history of previous mental disorder, most of those patients are not accepted for admission by the psych department, and the family members don't want to take the patient back home for their safety. Is it lawful to ask the police to detain? If not, what can be the further management of the patient? Doc, as I explained earlier, simply because substance abuse is a mental disorder, no doubt in that. Drinking alcohol, simply drinking alcohol or smoking a joule of cannabis or two is not mental disorder. If it is like that, all nearly 99% of population, they drink alcohol, but they are not alcoholics. Only 10% of them are alcoholics. And so merely having a mental disorder, we cannot detain them except through the act, either Mental Disorders Act or by CPE. CPE only through the courts and the presidents. So Mental Disorders Act through the district commissioner or the master of the High Court. So in case of here, so we have to see the aggressive behavior. Is a bad behavior. Is the bad behavior, is that behavior due to his badness or madness? You have to, you have to clarify. After drinking alcohol, you have no business to hit somebody. If they're hitting somebody, aggressive somebody, then it is they are violating the law. Whether they are sane or insane, they have no business to violate the law. Once the law is violated, so it should be reported to the law officers, that is police. So the law should take its own course. Then if he is suffering from any mental illness and if he is insane at the time of the incident, then the courts will ask us a report. We will provide the reports to the courts. So what to be done? When a patient is aggressive because of his bad behavior, for example, then it is Sbrana hospital cannot detain bad people. There is no medicine for bad behavior. We have medicine for mad behavior. Sorry to use the word, it is psychosis. We have medicine for psychosis, not for bad behaviors. Bad behaviors, we call them antisocial behavior. Antisocial behavior people, they should go to the prison. not to mental health. So it is an abuse of psychiatry again. So to prevent the abuse of psychiatry, actually, these laws came into being, existence. That is Mental Disorders Act. So what we have to do, whether such client to be treated as inpatient or not. Number one, first, the duty doctor will assess the client, whether such patient can be treated as inpatient or outpatient. If to be treated as inpatient, voluntary or involuntary. If the client is agreeing to be treated as voluntary, we have no problem if the age is 21 years and above. If the age is below 21 years and below 16, then if they're above 16, then no problem. If below 16, then the parent should give the consent for voluntary admission. If the patient is not willing for admission, then what we have to do? We have no way. If he is neither danger to self or to others. Suppose if he is danger to self or to others, danger to self. For example, last week we have a critical, a very case, very interesting case. The patient wanted to kill himself. The suicidal scale, we did, the duty doctor did the suicidal scale. It was 9 out of 10. That means he may commit suicide at any time. And the duty doctor told the client and his mother that the patient should be admitted. Then mother was not willing for admission, neither the patient. So they don't want to be admitted. Then they call the duty psychiatrist, what should be done. Suppose the similar in the medical cases also. Suppose a patient came to you with ruptured ectopic pregnancy or ruptured appendicitis with acute abdomen. And the patient is not willing for treatment or operation. And the relatives are also not willing. What you will do? On humanitarian grounds, we have to admit the client to save the life of the client. Same applies in psychiatry also. If the patient is danger to self or to others, and if the duty psychiatrist, also duty medical officer is satisfied that he is danger to self, then we will admit even without his consent. And the next reception process, reception orders or urgent application, things will follow later. So with abnormal behavior, definitely. With abnormal behavior means he's psychotic. So if he's psychotic, then we have to admit if he's danger to self or to others. But voluntary or involuntary. Involuntary through the district commissioner. And if he is really danger to self or to others, then we can detain him temporarily on humanitarian grounds to save his life. But if the duty doctor thinks that he is neither danger to self or to others, and the patient is not willing for admission, we cannot admit. It is violation of their right, and we go to jail. I think I have answered. Please share the reference page again. The reference page, doc. Yeah, this is the reference page. Mental Disorders Act 1969, government printer, Gavroni, and it is available. It is, I think, 10 puller. And World Health Organization Mental Health Atlas Country Profile, Botswana Criminal Procedure Code, and there is a big book for the lawyers. And we psychiatrists are concerned only section 157 to 175. And mental health legislation Botswana by UB, J. Mafisa and Mafisa, Lunacy Defense in Botswana Criminal Law, and comrades. This Mental Disorders Act is going to be repealed shortly, and Minister of Health is coming up with a new act called Mental Health Act 2023. And we psychiatrists contributed, and many international level also. From WHO, we have the inputs, and also UN also have the inputs, and many international psychiatrists also give their inputs. And with all these things, draft was prepared, and draft was prepared, and the draft was agreed by the cabinet, and it was approved by the cabinet, and is now in the public domain. After having the public inputs, then the act will be presented to the Parliament, and once the member of the Parliament go through the act and give any amendments, and after the amendments and after discussions, it may be published in the Gazette, and then it will become an act. And in the new act, this reception order business was taken away. and the district commissioners were not involved because they are unnecessarily they are dragged into many court cases because of their involvement. And in their place, 2 psychiatrists in the hospital will take a decision whether the client can be admitted or not. And there are so many other things are there, which I may take when the act comes into being. So now it is still under consideration. I think, Doc, I can take up this one. Now, what disorders have been reinstated after mental insanity? What disorders have been reinstated after mental insanity? Why do we have to keep patients in prison when they are mentally insane, despite the unavailability of multidisciplinary mental teams, as in psychiatric patients? It's a very good question, Doc. And I think when I told safe custody, either as per the act, they can be put in either in the prison or in the hospital. Why? That is a good question. By the time the trial comes up, it may take 3 to 4 years. By that time, the patient will become very stable. And his lawyer will argue in the court, the client doesn't want to be in mental hospital. Of course, why in mental hospital if the patient is not suffering, acutely suffering, and that will increase our load in the hospital also. Then the judge will ask the psychiatrist. The psychiatrist will go to the court and judge will ask where can I keep the client. Then so we suggest the judge, my lord, if the client is stable, he can be in the prison, and from the prison every month he can be reviewed as an outpatient. Since the patient, if the patient is still having psychotic symptoms and better, he should be in the hospital for the treatment. So it depends upon the client. So it goes by case. So, but I agree with you. Those who are in the prison, unfortunately, they may not get this benefit of what do you call sheltered employment program, and also the leave, the therapeutic leave facilities. And so we are seeing that one how to be solved out with the mental health board. Those who are stable for so many years, we want to take them back to Sbrana hospital so that they will undergo through these programs also. And once they are stable, and we can present to the mental health board for release. I think I have answered that question. Or maybe you are asking, when temporarily, suppose in Ghansi there is no restraining room, or in Sabong there is no restraining room in the hospital, and when the violent patient is transported to Sbrana, up to that stage, what we should do? Sometimes it is illegal to put in a police cell, but on humanitarian grounds, not to not for the sake of the client, so that he will not commit suicide nor he will not harm others. So they are kept on humanitarian grounds in the police cell for a brief period, say 1 or 2 days, until the transport is arranged. So we have such cases, and some complaints are there. But every hospital should have a psych unit with minimum 1 or 2 restraining rooms, and 3 to 5 beds should be there. But unfortunately, in many of our other hospitals, there are no restraining rooms and there are no psychiatric beds. And of course, our Minister of Health is looking into it. And within 2 to 3 years, I think every district may have one psychiatrist. Now we are training 5 psychiatrists under the UB medical school every year, 5 to 6 psychiatrists. And the new psychiatrist will come next year. They will finish this year, their 4th year. So they may be put into use by next year. 4 5 psychiatrists may come into the availability. So within 3-4 years, we have more psychiatrists, and every DHMT will have 1 psychiatrist. And maybe by that time, we'll have psych units, proper psych units, not simply namesake unit. We will have proper psych units. I think I might have answered that question. Do we have duty of care which lasts for 72 hours? This can be applied by any practitioner in case of emergency, when one is not willing to be admitted. So, doc, if one is not willing to be admitted, so we have no provision to detain. It is unlawful. Unless you are satisfied that on humanitarian grounds, you can detain him, like in the, as I give the example. If we have, if the patient is highly suicidal, if the suicidal scale is 8 and above, and if he is danger to self or to others, then if he is not willing and the parents are not willing to go to the district commissioner, or they don't have any provision at that time, and you have a right to save the life of the client and to save the community also. In such cases, you can detain. You can detain under humanitarian, and you should explain in case if they go to the court, and you have to explain your stand, and definitely the judicial officers will protect you if your intention is good, and if the intention is for the good of the client, for the welfare of the client, if you're detained. I think I have answered that question. So, Doc, I think I completed the doubts.
No, no, you did very well, Doc. You completed all the doubts. I think right now we'll just open up the floor to anyone who has any I don't know, virtual question. Anyone who wants to speak verbally to Doc.
Doc, how to increase the volume? I have a little volume only. Is there that side or this side volume?
Or maybe it's me, Dr. Davu. Maybe I should increase my voice, but
Okay.
Can you hear me better?
No, I can hear you when you raised your voice. No problem.
Yes, yeah. No, it's me. Hey, I'm exhausted, but colleagues, doctors, is anyone with a burning question or any comments before we wrap up?
And please note down my number. You can call me at any time, 24/7. I'm helpful to the doctors in the country if they are have any trouble with the psychiatric patients. And my email also you can note down.
We thank you too much, Doc. Yeah, very kind man. And from the interactions in the BDU group, we really appreciate your direction and your advice. So we really appreciate. And I see that no one is really wants to make any comments. So maybe let me just take this opportunity, Doc, to just to really thank you for taking time out of your busy schedule. I know you do a lot of outreaches. You're a consultant, but you took time at the end of the day to come and give us this amazing presentation, which by the way is recorded, so we will share with different doctors so that they can benefit and they can make a reference in case they missed anything, or in case they forget and they want to go back and see what did Dr. Davu say about this particular instance. So really, sir, I really thank you and appreciate today's presentation.
Thank you very much, Doc, for your kind words. Thank you very much.
Yes. No, anyway, yes, sir.
Shall I click on the stop share, or what should I do?
Yes, you can.
Or anybody is waiting? Any questions?
I know there's somebody, Mr. iPhone 13G says, can we call anytime?
iPhone 30G, okay.
Yeah, I don't know about that. I don't know about calling anytime, but I think let's be reasonable with how we consult with Dr. Davu. During the day we can call him, but at night, if we're unable to reach our supervisors, our seniors, and we have an emergency and we don't have any choice, then maybe that's when we contact you. But let's be considerate of Dr. Davu's generosity. So thank
somebody called me. We can call at any time. Yes,
Okay.
doctor, because psychiatry is my passion. And if the
Yeah.
duty psychiatrist is not available, you can call me at any time if you are in emergency situation, and I will assist you. There is no problem. That is why I'm sharing this is my personal number. You can
Wow.
share, you can keep that personal number with you, and any doubt at any time, no problem, doc. So I will be happy to assist you.
Wow, no, great. No, thank you so much, Doc. And thank
you,
you for all those that were present in today's session.
Yeah.
All right. Thank
Okay,
you.
doc. Thank you.
All right.
So shall I stop share, doc, here?
Yes, yeah, stop share and
Okay.
then I'll
Okay,
end the meeting from here. Thank you.
Thank you.